Hello viewers, in this lesson we will learn about the legal protection available to the bankers. Objectives: to learn about the legal protection available to the paying banker, to learn about the legal protection available to the collecting banker, to learn about the law on dishonor of payments by a banker. Viewers, now we will learn about the legal protection available to the paying banker. A paying banker is one who pays to his customer the money. A banker is obliged to make payment to his customer on the demand made by the customer, subject to the availability of sufficient balance in the account or any overdraft arrangement. For banking operations, invariably, the banker has to follow the provisions of the Negotiable Instruments Act 1881, apart from complying with various other related legislations, like the Reserve Bank of India Act 1934, the Banking Regulation Act 1949, and other legislations. Further, invariably, the provisions of the Indian Contract Act 1872 apply. Apart from paying directly cash to his customers, a banker would pay through various modes like collection of checks, demand drafts, money transfers, internet banking, and like ones. The banker is under a statutory obligation to honor the checks drawn by his customers. As a drawee of a check, the obligation of a banker is delicate and of high importance. The paying banker's failure to honor his commitment without sufficient reasons may make him liable to compensate the drawer for any loss or damage caused by such default under Section 31 of the Negotiable Instruments Act 1881. Hence, the paying banker must take proper precautions while making payment to his customers, such as proper presentation of demand for payment by the customers, proper form of the check, date of the check, stale checks, post-dated checks, amount of the check in case of check payments, and like ones. Further, the bank must follow the guidelines, circulars, orders, instructions of the Reserve Bank of India issued from time to time in payment of checks and other modes of demand for payment like presenting withdrawal forms. If the banker makes payment to its customers as per the norms, it is protected from any legal consequences. The various situations under which the paying banker gets legal protection under the law are narrated hereunder. 1. Material alteration. Any alteration of a negotiable instrument which affects its operation substantially and changes the liability of the parties concerned is termed as material alteration. According to Section 87 of the Negotiable Instruments Act, any material alteration of a negotiable instrument renders the same void as against anyone who is a party thereto at the time of making such alteration and does not consent thereto, unless it was made in order to carry out the common intention of the original parties. Further, any such alteration, if made by an endorsee, discharges his endorser from all liability to him in respect of the consideration thereof. The paying banker must be cautious that these provisions are to be read with the other provisions of the Negotiable Instruments Act, such as Section 20 relating to inchoate stamped instruments, Section 49 relating to conversion of endorsement in blank into endorsement in full, Section 86 relating to the issues that the parties not consenting are discharged by qualified or limited acceptance, and Section 125 relating to the payment of checks crossed generally. Protection to the paying banker in case of material alteration. Even though the material alteration renders an instrument void, Section 89 of the Negotiable Instruments Act provides protection to the paying banker. According to subsection 1 of Section 89, where a promissory note, bill of exchange or check has been materially altered but does not appear to have been so altered, or where a check is presented for payment which does not at the time of presentation appear to be crossed or to have had a crossing which has been obliterated, payment thereof by a person or banker liable to pay and paying to same according to the apparent tenor thereof at the time of payment and otherwise in due course shall discharge such person or banker from all liability thereon. And such payment shall not be questioned by reason of the instrument having been altered or the check crossed. According to subsection 2, where the check is an electronic image of a truncated check, any difference in apparent tenor of such electronic image and the truncated check shall be a material alteration, and it shall be the duty of the bank or the clearing house, as the case may be, to ensure the exactness of the apparent tenor of electronic image of the truncated check while truncating and transmitting the image. According to subsection 3, any bank or clearing house which receives a transmitted electronic image of a truncated check shall verify from the party who transmitted the image to it that the image so transmitted to it and received by it is exactly the same. Thus, the protection to the paying banker under subsection 1 is subject to the provisions of subsection 2 and 3 of section 89. The basic requirements for availing protection are that the banker must ensure that the alteration is not apparent to the eye and the payment has been made in due course as defined in section 10 of the Negotiable Instruments Act. In Bank of Maharashtra versus Messrs. Automotive Engineering Company, the Supreme Court held that there is nothing in the Act which makes obligatory for the bank to subject every check to examination under ultraviolet ray lamp, though it could be prudent to examine under the said light, and the bank will not be deemed as failed to take reasonable care in passing the check for payment without subjecting it for further scrutiny under ultraviolet ray lamp. 2. Protection on payment of checks and other negotiable instruments. The paying banker has to take all precautions in passing the various checks for payment. He should ascertain that the checks bear the correct signature of the drawer as per the specimen signature. He should also ensure that the other related issues like the date, amount, and such things are properly carried out. The paying banker, as a part of professional hazards, undergoes high risk in paying the checks, as he is under a statutory obligation to pay the amount of check to the right person according to the instructions of the customer as provided under Section 78 of the Negotiable Instruments Act. However, statutory protection is available to the paying banker under Sections 82 to 90, 123 to 131A, and other related provisions of the Negotiable Instruments Act and other allied legislations as follows. A. Under Section 85, read with Section 16 of the Negotiable Instruments Act, the paying banker is given statutory protection if he makes payment of an order check with forged endorsement, provided that the banker finds genuinely that the endorsement is regular and further the payment was made in due course as provided under Section 10 of the Negotiable Instruments Act. B. In case of payment of a check to a wrong person in mistaken belief by the banker, the amount can be recovered under Section 72 of the Indian Contract Act 1872. C. The banker is discharged from the liability if he makes payment of an uncrossed bearer check to the bearer in due course, and he is protected under Section 85 of the Negotiable Instruments Act. D. The banker is protected under Section 128 of the Negotiable Instruments Act in case of payments made by him of crossed checks in accordance with the instructions of the drawer conveyed through the mode of crossing. However, this protection is subject to compliance of the provisions of Section 10 relating to payment made in due course and Section 126 relating to the requirements of crossing of checks of the Negotiable Instruments Act. The banker can refuse payment of checks and get statutory protection under various circumstances which are narrated in the foregoing paragraphs. E. Under Section 131 of the Negotiable Instruments Act, a banker who receives payment for a customer and pays it to him in good faith and without negligence gets statutory protection subject to fulfillment of the conditions thereon. Viewers, we will now learn about the legal protection available to the collecting banker. Collecting banker means the banker who is entrusted by his customer to collect the amount of the checks or other negotiable instruments like the bill of exchange from another banker. The collecting banker presents the instruments for encashment to the drawee banker and on its realization credits the account of the customer with the amount so realized. Today, globally, collection of negotiable instruments is a very important function of a banker, and the banker may act as a holder for value or holder in due course as provided under Sections 8 or 9 of the Negotiable Instruments Act. He can also act as an agent of the customer as provided under the provisions of the Indian Contract Act. The collecting banker is provided with statutory protection as follows. A. Under Section 131 of the Negotiable Instruments Act, a banker who is in good faith and without negligence received payment for a customer of a check crossed, generally or specially to himself, shall not, in case the title to the check proves defective, incur any liability to the true owner of the check by the reason only of having received such payment. Explanation 1 to this provision states that a banker receives payment of a crossed check for a customer within the meaning of the section Notwithstanding that, he credits his customers' accounts with the amount of the check before receiving the payment thereof. Under explanation 2, it shall be the duty of the banker who receives payment based on an electronic image of a truncated check held with him to verify the prima facie genuineness of the check to be truncated and any fraud, forgery, or tampering apparent on the face of the instrument that can be verified with due diligence and ordinary care. Thus, to avail the statutory protection, the collecting banker must ensure that the check must be a crossed check, whether crossed generally or specially, and the payment must be received for the customer. Further, the payment must be received in good faith and without negligence. Here, the wording without negligence implies that the banker did not have an iota of doubt about the payment. The onus of proof that the banker was not negligent in collecting the check lies on the banker himself. Some of the examples of negligence of the banker are that the account of the customer was opened without proper introduction, that the endorsements are irregular, that no enquiry was made in case of doubtful transactions, that no caution was taken on the note of not negotiable crossing, that an account payee check was collected by mistake for somebody not meant for, and like issues. B. The collecting banker, while acting as an agent of his customer, gets protection under the provisions of Indian Contract Act relating to agency. He is responsible to his customers for all his acts of commission, omission, or mistakes. Acts of commission mean acts which are not supposed to be committed or committed, and omission means acts which are supposed to be committed or omitted. Mistakes could be of varied nature, including bilateral and unilateral mistakes, as contemplated under the Indian Contract Act. The collecting banker, to avail the legal protection, must also ensure that the checks for payment were made within a reasonable time. With regard to the presentment of negotiable instruments, the relevant provision pertaining to bankers under sections 61 to 90, especially the provisions of section 70 to 84 of the Negotiable Instruments Act, must be complied with by the collecting bankers. The Supreme Court in Keshri Chand Jai Shuklal versus Shillong Banking Corporation Limited held about the legal position regarding the duties of a collecting banker as follows. A banker entrusted by his customer with the collection of a check is bound to act according to the direction given by the customer, and in the absence of such a direction, according to the usages prevailing at the place where the banker conducts his business and applicable to the matter in hand. The banker is also bound to use reasonable skill and diligence in presenting and securing payment of the check and placing the proceeds to his customer's account, and in taking such other steps as may be proper to secure the customer's interest. Apart from the above duty, the collecting banker is also under a duty to serve to his customer the notice of dishonor in case written off checks by the paying banker, as he is a holder for value in those circumstances. In this connection, the bankers must follow the relevant instructions of the Reserve Bank of India also. Viewers, now we will learn about the law on dishonor of payments by a banker. The banker gets statutory protection subject to his fulfillment of the various legal requirements as narrated afore. The banker basically cannot refuse payments as provided under Section 31 of the Negotiable Instruments Act. However, this statutory duty is exempted under certain circumstances, and if payment is made under those circumstances, the banker would be fastened with a liability to compensate the customers. Those circumstances are narrated hereunder. 1. Countermanding of payment by the drawer. A check is an unconditional order of the drawer to the banker, and the drawer is entitled to cancel such an order at any time before its payment is made. This is called countermanding the payment by the drawer. The right to countermand payment of a check is vested in its drawer. The prudent practice is that the order to stop payment must be given in writing and it should be signed. However, the customer care service centers can take oral instructions of the customers on proper proof of identification. The banker is liable to the drawer if he pays the check even if by oversight after the receipt of any countermand order. 2. Death of the drawer. The banker must stop payment of the checks signed by his customer on receipt of reliable information about the death of the customer, as the relationship between the bank and the customer ceases on the death of the customer. In case of different accounts operated in different branches of a bank, notice of death must be intimated to each branch separately. This aspect was dealt with by the Supreme Court in United Bank of India versus Srimati Kanan Bala Devi and others. Once the banker comes to know about the death of his customer, he should keep the account in suspense until the legal representatives produce proper proof to succeed to the account of the deceased, like a succession certificate or a probate of the will or a letter of administration. On making payment in accordance with the said certificate or any other court order, the banker is discharged from his liability and he is fully protected under law. 3. Insolvency of the drawer. In case of insolvency of any account holder or the partner of a partnership firm or a joint account holder, or in case of bankruptcy of a partnership firm, or in case of liquidation of an incorporated company, the entire power of administration of the bank accounts vests in the court, and the court directs the official receiver or official assignee or the official liquidator, as the case may be, to act under its instructions. Earlier, the insolvency of a person was covered under the provisions of the Presidency Towns Insolvency Act or the Provincial Insolvency Act. Today, the bankruptcy and insolvency of any individual, firm, or a company are governed by the provisions of the Insolvency and Bankruptcy Code 2016, read with the provisions of the Indian Partnership Act in case of a firm and the Companies Act 2013 in case of the companies. The bankers must follow all the relevant provisions of these legislations. 4. Insanity of the customer. If the banker receives confirmed information from any authorized person about the insanity of its customer, he can refuse payment of that customer's checks. In case of a dispute, he will have to wait for any order of a court of law. 5. Justified refusal of payment of checks by a banker. The banker is justified in refusing payment of the checks of his customers in case of post-dated or stale checks, wrong drawing of checks, material alteration, forgery, insufficient funds, inconsistent signature of the customer, a garnishee order, breach of trust, defective title of the party, notice of assignment of credit balance under Section 130 of the Transfer of Property Act 1882 by a customer and the like ones. In case of dishonor of checks, the paying and collecting banks must follow the circulars, guidelines, orders of the Reserve Bank of India. The paying bankers, without any delay, must convey to the collecting bankers the information about the dishonored checks, instruments, and must send them to the collecting bankers. The collecting bankers must, without any further delay, bring to the notice of their customers about the dishonor of the instruments. Otherwise, the banks would not get the statutory protection available under law. In fact, in the present day scenario, most of the banks send SMS alerts to the customers about the dishonor of the instruments. Well, viewers, I hope you have enjoyed this lesson. We'll meet again in the next lesson. Thank you.